Senior Minister of State Edwin Tong.
Mr. Speaker, I thank the members who have spoken up in support of the bill. Let me address the questions directly. First, questions about the VRI. Mr. D'Souza asked if non-police law enforcement officers will need different skills, training, resources to investigate these offences. As with all legislative amendments, before bringing the changes into force, the relevant agencies will assess what kind of training or preparation is needed and will get that done. There is an interagency work group comprising MHA, MinLaw, AGC, the police and other law enforcement agencies which oversees the development of policies, operational procedures and also training plans to ensure uniformity in VRI implementation across the agencies. This work group will work towards ensuring that the investigation of VRI offences is done to a common high standard across all agencies. Mr. D'Souza also asked why the non-police officers exercising the powers to investigate VRI offences do not need to be the rank equivalent to an inspector of police, but are deemed to be of that rank for these purposes. This is to match the existing powers of those officers. For example, under Section 32 of the MDA, the Misuse of Drugs Act, a CNB officer investigating an offence under that Act has the same CPC powers as a police officer investigating an arrestable offence. In exercising those powers, the CNB officer is deemed by Section 32(3) to be an officer not below the rank of an inspector of police. Provisions like Section 32 of the MDA and the proposed Section 40B of the CPC recognize the fact that officers of specialized law enforcement agencies such as the CNB are highly trained and are able to competently and responsibly exercise the investigative powers given to police officers of the rank of inspector and above. Ms. Sylvia Lim asked which agencies have commenced using VRI, for what kinds of offences, and for the assessment of the usefulness of VRI in investigations and as evidence. VRI has been used by the Serious Sexual Crime Branch of the CID in investigations into rape and by the CNB to investigate certain drug trafficking offences. Several police land divisions are also preparing to use VRI. Early feedback from the ground and from these agencies is that VRI is useful to investigators and our officers are confident in the VRI system. So far, there has not yet been a case where a VRI recording has been used as evidence. As more cases go through the criminal justice system, we will continue to gather feedback from the implementing agencies in order to further refine and improve the VRI process. I thank Ms. Lim for being supportive of this, and with reference to the suggestion in 2008 that MinLaw was dismissive of this during COS, let me just clarify the position. The answer then was that MHA would take ownership of this issue, and at that stage, whilst MHA had no plans to implement VRI, they were nonetheless, and I quote, MHA's position is that the issue of video recording as well as other operational issues should be looked into in the following manner. There should be a fair system which seeks to ensure that crimes are solved, and the system should also ensure that the rights of accused are protected. If an accused wishes to challenge the statement given by him, there are clear avenues available today. So that was the position in 2008, not quite so dismissive as Ms. Lim has suggested. Next, there were several questions on the removal of sensitive information from disclosed materials. Mr. D'Souza asked if the defence can easily seek the court's determination of whether such a removal or redaction should stand. The defence may apply for the court's determination without any procedural barrier. For example, leave of court will not be required. However, to succeed, the defence will need to satisfy the court that the prosecution should not have redacted the relevant information, either because it was not sensitive information, because the prosecution is relying on it as evidence, or because it tends to assist the defence or undermine the prosecution's case and therefore must be legally disclosed. That's the test in Carter's case. Mr. D'Souza asked whether the requirement that the court view the disputed redacted material in the absence of the defence violates an ethical rule against a party communicating with the court without the other party also being present or able to reply. I would like to make it clear that the rules of natural justice will continue to apply to those proceedings just as they have done in other proceedings. This means that both parties will be able to make submissions on the legality of the redaction and also rebut each other's submissions. While the court must view the disputed material in the absence of the defence, This does not mean that the prosecution will be allowed to make submissions in the absence of the defense. In other words, you make the submissions, the defense can respond, but the court views the disputed material only in the absence of the defense. Mr. D'Souza also asked how this procedure takes into account the understanding that the defense would be best placed to know whether something would strengthen his own case. This question relates to the common law principle from the case of Kadir, which I mentioned earlier, that the prosecution must disclose unused material that tends to strengthen the defense's case. Mr. D'Souza's question calls to mind the argument sometimes advanced before the courts that the defense should receive disclosure of material for the purposes of arguing that it should be disclosed. The High Court in fact considered precisely this point in Winston Lee's case and held that even where it fell to the prosecution to show that in compliance with its Kadir disclosure obligations, the disputed material may be shown to the court but not to the defense. And to quote the judgment on this, to allow the defense to examine the undisclosed material on a preliminary basis simply because there's a dispute on disclosability has a similar practical effect to disclosure, and this would in essence be going further than the situations of disclosure envisaged in Kadir. The wording in the proposed legislation is entirely consistent with this common sense position. In similar vein, Mr. D'Souza asked how we can ensure that information is indeed disclosed where it is valuable or relevant and necessary to the defense's case. The courts have set down detailed procedures to fairly balance the competing interests in this area. And the High Court's decision in Winston Lee's case was then subsequently brought to the Court of Appeal in a criminal reference. And our apex courts have stated that while the public prosecutor is presumed to have complied with his disclosure obligations on account of his constitutional office, this presumption can be rebutted. Once the defense satisfies the court that there are reasonable grounds to believe that a prosecution has failed to comply with its Kadir obligations, the court will look to the prosecution to show that it has complied. With the defense assisting the court in this regard, we are confident that the outcomes will be fair when the Kadir principles are applied in the context of the redaction of sensitive information. Finally, Mr. D'Souza asked a question from the other perspective, from the other side of the spectrum, I think, which is when there is a need to disclose such information, even though it is sensitive information, what will be done to safeguard the sensitive information from being abused? The prosecution will weigh very carefully whether, in the first place, whether to use sensitive information as part of its evidence, and will only do so where it is necessary. If unredacted information, sensitive information has to be used in a criminal proceeding, various measures can be taken to mitigate the risk of publicity. First, if there is sensitive information and materials disclosed in the statutory pre-trial disclosure process, the court may order that the accused and his advocate cannot communicate it to any person. Breach of this order would be an offence. It is also worth noting that generally the media are not allowed to publish reports of information contained in materials disclosed during the statutory pre-trial disclosure process, except the basic facts of the case. Second, the court may order that the matter be heard behind closed doors, in camera. Finally, if the sensitive material contains or concerns the identity of a witness, the court can order that such information not be published. This is commonly known as a gag order. Moving on to the next area being amended, Mr. D'Souza asked for the rationale of giving the courts and the registrar the power to shorten timelines and in relation to the procedure for reopening concluded cases. I should highlight that both parties will be given the chance to make amendments about the timelines before the court makes a decision to either shorten or extend them. So that's in the usual way where the court entertains submissions from both parties. The court will take on board all the facts and arguments, taking them into account and deciding whether it is in fact just to make the order or not. I stated in my opening speech that this proposal was designed to enhance efficiency and allow for more flexibility. Let me illustrate the point with one example. Let's say an application to reopen a concluded case is filed very late and close to the time the sentence is to be carried out. For example, a caning sentence, which will be irremediable. With this amendment, the court will be able to consider whether to shorten procedural timelines to have the application heard and resolved more quickly. And we have no doubt that the courts, in applying its discretion to the facts of each case, will have the fair balance between the parties' interests at heart when deciding. Finally, there were a number of questions on the backdating of the RT sentences, and let me deal with that. Both Ms. Lim and Mr. D'Souza asked what steps the agencies will take to avoid or minimize remand where RT is a possible sentence. First, as I mentioned earlier, the agencies will work to identify the remand cases where the accused is under the age of 21 early. This age group includes all accused for whom RT may be ordered. The identification of these cases may be done even before charge. Once such cases are identified, the prosecution and investigators will take steps to expedite the case and reach the sentencing stage as quickly as possible. In addition, in appropriate cases, remand can be avoided by offering a reduced bail amount. For example, if the sureties have difficulty raising bail in those situations. Release on bail with electronic tagging can also be used as an alternative to higher bail amounts where appropriate. The CJRA amended the CPC to expressly allow the use of electronic tagging as a condition of bail. Ms. Lim also asked for confirmation that a court will not have an RT sentence take effect on a date later than the date it was passed if the offender is already in pre-sentence remand, as I understand the question. Yes, that would be so, and in such a situation, it would invariably start immediately. And generally, the CPC's powers empower the court to direct that a sentence of imprisonment, RT or CT or preventive detention, the court has the power to order that it takes effect at a later date than the date it was passed. And this, however, is usually done on the request of the offender in most of these cases, to allow, for example, time to sort out personal affairs and so on before serving the sentence. So the usual position is if you are already in pre-sentence remand, then unless the offender requests, you would simply carry on. If the offender is already in remand in that situation and they are not requesting bail to sort out personal affairs or other matters, then there's generally no reason to postpone the commencement. Finally, Mr. D'Souza asked whether the court also considered disallowing backdating for CT of sentences. These are corrective training sentences. As background, although CT sentences share the rehabilitative element with RT, they apply to a different group of offenders. CT applies to adult offenders, as opposed to RT, who have committed one or more offences with maximum sentences of 2 years imprisonment or more, and also have relatively serious previous conviction. These adult repeat offenders can be sentenced to CT for a minimum of 5 and a maximum of 14 years, without entitlement to remission. Considering the long minimum duration of CT sentences, there is less risk that backdating of such sentences will interfere with any rehabilitative efforts during the sentence. In conclusion, Mr. Speaker, I thank the members for the contribution, both Ms. Lim as well as Mr. D'Souza, to this debate. The government is continuously working towards a progressive, balanced and modern criminal justice system that protects society from crime. This bill contributes to this effort by building on past reforms and also at the same time enhancing their effectiveness. With the support of this House, I beg to move.
The question is that the bill be now read a second time. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it.
Criminal Procedure Code Amendment Bill.
Committee Sage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
Question is that the Parliament will immediately resolve itself into a committee on the bill. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 10 stand part of the bill. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Law.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it.
Criminal Procedure Code Amendment Bill.
Leader.
Speaker, I beg to move that Parliament do now adjourn to a date to be fixed.
Question is that Parliament do now adjourn to a date to be fixed. As many as are of that opinion say aye. Aye. To the contrary say no. I think the ayes have it. The ayes have it. Order. Order.